You know, I've been thinking about this this webinar for a little while, and actually, you know, I think there's more fitting titles. It's like why an IP strategy is necessary to be competitive, to have a competitive advantage, or even a better one is probably why you must have a business strategy aligned with an IP strategy in order to have competitive advantage and be commercially successful, frankly. I've got some slides here I want to go over. And you know, one thing that came to mind, first of all, on how important this topic is the fact I was asked to speak at an event about a year and a half ago. And there were universities that were there, startups, different researchers, and I was part of a panel at the front. And a lot of people were asking questions, you know, why is it that startups and SMEs are having trouble being commercially successful in Canada? Why are they not retaining their IP? Why are they being bought by big US companies and we lose the IP? And so people were coming up with reasons about a lack of funding in Canada and a lot of different reasons. But honestly, to me, I think the biggest problem is the fact that companies, you know, whether you're a startup, SME, even mid-size, do not have a proper business strategy and one that aligns with an IP strategy, as I was saying. And so with part of my slides here, when I click on this next one here, this is why I often write, you know, a lot of the problem is when you're a startup or a SME, you're often headed up by the initial inventor who created the technology, and they take on the role as being the CEO or the leader. That's fine. And oftentimes, you know, these leaders lack business acumen, let alone sort of IP awareness, as I say. But this is where, to me, it's critical that you have organizations like, you work with organizations like North Forge, you get funding under programs like ElevateIP to help you with this aspect, you know, because as I say here, you may have incredible technology, but unless you have a business strategy built around a unique market value proposition, there's no guarantee that your business will be successful. And so not only do you need a business strategy, but it's got to be aligned with an IP strategy because they go hand in hand. And this is what a lot of organizations do not realize. Organizations will have a business plan and they will have an IP plan, which is usually just an IP filing plan. That is not an IP strategy and does not go into a proper business strategy. I'm going to put on a few minutes of a video that I really like. It was put on by a professor at University of Toronto. He's well known for business strategy. And I'm just going to play a few minutes of it because it's important to talk about the difference, why it's important to strategize and not just plan.
So what's a strategy? A strategy is an integrated set of choices that positions you on a playing field of your choice in a way that you win. So there's theory. Strategy has a theory. Here's why we should be on this playing field, not this other one. And here's how on that playing field we're going to be better than anybody else at serving the customers on that playing field. That theory has to be coherent. It has to be doable. You have to be able to translate that into actions for it to be a great strategy. Planning does not have to have any such coherence. And it typically is what people in manufacturing want, the few things they want to build a new plant, and the marketing people want to launch a new brand, and the talent people want to hire more people. There tends to be a list that has no internal coherence to it and no specification of a way that that is going to accomplish collectively some goal for the company. The plan is quite comforting. Plans typically have to do with the resources you're going to spend. So we're going to build a plan. We're going to hire some people. We're going to launch a new product. Those are all things that are on the cost side of businesses. Who controls your costs? Who's the customer of your costs? The answer is you are. You decide how many square feet to lease, how many raw materials to buy, how many people to hire. Those are more comfortable because you control them. A strategy, on the other hand, specifies an outcome, a competitive outcome that you wish to achieve, which involves customers wanting your product or service enough that they will buy enough of it to make the profitability that you'd like to make. Tricky thing about that is that you don't control them. You might wish you could, but you can't. They decide, not you. The harder trick. So that means putting yourself out and saying, here's what we believe will happen. We can't prove it in advance, can't guarantee it, but this is what we want to have happen and that we believe will happen. It's much easier to say, I'll build a factory, I will hire more people, etc., than I will have customers end up liking our offering more than those of competitors. The tricky thing about planning is that while you're planning, chances are at least one competitor is figuring out how to win. So, the second thing I do is say, lay out the logic of your strategy clearly. What would have to be true about ourselves, about the industry, competition, about customers for this strategy to work? Why do you do that? It's because you can then watch the world, right? And if something that you say is in the logic that would have to be true for this to work is not working out quite the way you hoped, it'll allow you to tweak your strategy. And strategy is a journey. What you want to have is a mechanism for tweaking it, honing it, and refining it so it gets better and better as you go along. Another thing that helps with strategy is not letting it get overcomplicated. It's great if you can write your strategy on a single page. Here's where we're choosing to play. Here's how we're choosing to win. Here are the capabilities we need to have in place. Here are the management systems. And that's why it's going to achieve this aspiration that we have. Then you lay out the logic, what must be true for that all to work out, we hope. Go do it and watch and tweak as you go along. That may feel somewhat more worry-making, angst-making than planning, but I would tell you that if you plan, that's a way to guarantee losing. If you do strategy, it gives you the best possible chance of winning.
So I think that was a great video, and I encourage you to go on this link and watch the whole video, because this is sort of exactly what I feel companies, especially startups, SMEs, do wrong, is they don't know how to come up with a proper strategy and an IP strategy that goes along with it. So if I want to make note of a few things that Roger Martin said. A strategy is a theory. Here's why you choose to be on this playing field, and here's how on that playing field we're going to be better than anybody else at serving the customers. Lay out the strategy clearly. What would have to be true about ourselves, about the industry, about competition, about customers for this strategy to work? Strategy is a journey, and you need a mechanism for tweaking it and honing it. And you need to set out the capabilities that you have in place. Here are the management systems, and that's why it's going to achieve this goal, the aspiration that we have. That's a lot different than planning. And so if I now go to the next screen then, so what really, how does this align with an IP strategy? Well, an IP strategy is a unified set of choices and objectives that aligns with, supports, and is integrated with the business strategy. And this is my definition that I use, my quote. But it also involves a theory. Here's why the company should be cultivating and positioning its IP in a certain way, given the technology landscape it's playing in. And here's how, by creating, acquiring, protecting, managing, monetizing, commercializing, and enforcing its IP, the business is going to have a competitive advantage and be in the best IP position to meet its business objectives. And so a proper IP strategy is tailored then to the specific needs, capabilities, and resources of the business, and needs to be reviewed and updated regularly, as does the business strategy. So this is how they go together. And unfortunately, businesses keep them apart half the time. Your business, plan that they often have, and they'll have an IP plan, but really they go together. Your company ultimately has goals and objectives, and it's got a vision and a mission statement. The business strategy is something then that you strategize. It's a theory of how you're going to meet those goals and objectives. And it's only going to be successful if you have a proper IP strategy and basically innovation strategy as well linked to it. They're all work together because the business strategy will drive innovation. Innovation drives what you should be protecting. Same thing if you have an IP strategy based on what you're finding, and we'll talk more about this in the landscape, what your competitors and others are doing, that is going to help you develop your business strategy and your innovation strategy. They're all linked together. And so if you focus more on the IP strategy, you can tell then, knowing how they're so meshed together to have a successful business, that an IP strategy relies on several different things, several different factors. One is IP landscaping. As Roger said, what would you have to know about the competition, about competitors and their activities, the market itself? What would you have to know in order to come up with a proper business strategy? And this is where IP landscaping comes in. You're able to learn, where your competitors, suppliers, and others are innovating, where the trends are, where things are going. You're going to also learn, and we'll talk more about this, white spaces. Where can you, what are some of the areas you can innovate into? And then also you've got other aspects. A lot of people are not aware of all of the IP assets that they're sitting on, that they've developed. And often, I have clients come and they say, look, we want to file a patent application, to this. And once again, that's just an IP plan. But you've got to look at the technology and focus on what it is, what advantages is your IP giving you. And so you need to focus on them to make sure you're getting the benefit of you're helping your business strategy. So you need to really take the time to know what you have. A lot of companies are sitting on a gold mine of data, and they could use their data in different ways for IP, for licensing purposes or anything. They're sitting on a lot of trade secrets or know-how. You've got to know how to manage your trade secrets and be aware of them in the first place, because that will help with your strategy. Should you keep this as a trade secret, or is this something that you should file as a patent application? You can only know that once you've identified everything. And then that's where, sort of number 3 comes in here, an IP portfolio. You need to build an IP portfolio that will actually give you a competitive advantage in the space where you're actually wanting to play. That's actually going to provide you with the competitive advantage you want. If you just go willy-nilly filing anything out there, that's not necessarily going to get you anywhere. You need to focus on where you're going to receive the benefit, because then there comes the next step, IP commercialization. You can use IP in different ways. Sometimes it's used for defensive purposes. Sometimes you just want to file a patent application to get it out there published, so that nobody else can get a patent on it. And you frankly don't even care if you get a registered patent. It just becomes prior art. Sometimes it's absolutely key to your technology, and you want to make sure that this is technology that you're going to protect and you're going to enforce if necessary. Other times, you're going to have IP that you're going to want to license out. Maybe you're creating IP that can be a standard, and it can be the subject of a standard patent where everybody is going to want to use your technology, and they'll have to pay a licensing fee to be able to use it because it's become an industry standard. There's so many ways that IP comes in for your strategy. And then the last point is IP risk management. By having a proper IP strategy, you're managing your risks. What happens if that partner you were working with all of a sudden backs out of the deal? What happens? Like, there's no guarantees that you're going to be able to collaborate with the same people, the same suppliers. You have to be aware of what your competitors and everyone is doing basically at all times if you can. And that is always forming part of your strategy, and then your business strategy always adapts to it. When you get all this information, you have your strategy, and you've got all these different facets that I just talked about there. This is where you're able to hone in on what IP is absolutely critical to you. If you've learned from your market analysis, your IP, strategies that you've come up with, you'll know where you have a unique value proposition. You'll know what the market wants and values. And if you've done your proper IP landscaping and research, potentially also freedom to operate opinion, at least some different studies, you'll know the areas of unprotected IP. And so you'll be able to focus in on the optimal IP zone where you've got a market validated differentiation, market identified innovation space, and unique and unprotected IP. That spot there, using that within your business strategy is going to give you the best chances, best competitive advantage in the market. I'm going to go over a couple of examples that over my years of experience that I've dealt with. I've been asked to come in and sort of help companies with different situations. And I'm firstly going to give you a couple of examples of sort of strategy misalignment. So this first company that I'm aware of had incredible technology. And I'll say this is one of the best technologies I've ever seen in all my years of practicing. And it's useful in data center and cloud computing space. They had improved scalability, easy to increase the processing power in a very easy way, reduce costs, which is a big thing with data centers these days. And it was green tech and lower power requirements. All these things are important for data centers going forward. But the company did not have a proper business strategy, and in particular one, managed, aligned with an IP strategy. So what they wanted to do, they said, look, we're concerned about trade secrets, keeping these things secret with our engineers who are constantly busy, trying to monitor this stuff. So we just want to file for everything. Every invention that we kind of come up with, we'll just follow them. Now, whether they happen to help us with our business strategy or not, we don't really care. And the reason they sort of took this attitude is because they had a lot of financing. There's a lot of people, investors, who could see the potential of the company. And so they were, willing to invest a lot of money. And so they didn't mind throwing, hundreds of thousands of dollars at their IP. Problem is they had no proper business strategy. And so they had no strategy as to which sectors or industries to start with or focus on. They had no strategy of how to lure and win customers. And so you got to remember, no manager was ever fired for choosing IBM data center equipment. And so they don't want to put hang their hats on technology that maybe isn't proven to them. So they had to figure out a way, and they didn't, to lure and win different customers. They had no knowledge of freedom to operate based on different competitor IP. All they did was what Roger Martin said is a mistake, and you're going to lose if you do this. They had business plans to look. They would say, our technology is so good, we just have to ramp up quickly because we're going to have people running to us. So they greatly increased their marketing, their engineering teams, sales teams, distributors, resellers. And they got up to a large number of people. And unfortunately, things didn't work out. They squandered their financing rounds. They had waves of hiring and firing, and they can't afford their IP portfolio. This is why it's critical to focus on a winning business strategy aligned with an IP strategy. Another example. This is another a great client I had. Love these guys. They had high-end products in a specific retail space. Really innovative, high quality compared to what the competitors had. Large customer base in Canada and the US, somewhat in Europe, and they had high customer goodwill and product, recognition. These were a lot of great things. They were really smart with, with their IP strategy to a point. They filed patents on the functionality of their products, industrial designs to the way the products looked, which are very important features of shape pattern, orientation, and just the way they look. Trademarks for all their innovations, but they only did it in Canada and the US because that was their major markets. That's missing some key aspects of a proper IP strategy, because they had no business or IP strategy for their operations in China regarding manufacturing, contracts, competition, and they had no landscape studies or IP monitoring of what was going on in the market sort of around them. And that means both Canada and the US and China and other countries. This was very, very important, because what happened in this situation is they had manufacturing done in China because they had someone who was doing a great job, initially high quality, and they could get it much cheaper than if it was manufactured in Canada. They frankly couldn't do it here, unfortunately. What happened though is the product quality started decreasing. They wanted to shift manufacturing to another manufacturer there. They tested them out, it was really good. And they told the manufacturer that they were going to move. Well, what happened? The manufacturer had behind their backs filed sort of competing patents to their technology in Canada and China, stole their trademarks because they hadn't filed them, registered them in China. And what they did is they blackmailed the company. And they said, unless you keep your manufacturing with us, we're going to bring a lawsuit against you in China. And this is exactly what they did. So in China, you can register, they could register their trademarks and patents that this technology that they stole, and they registered them with the China Customs IP protection system. And as soon as the China Customs IP protection system had a copy of this IP, the company's name, and the fact that a court case, litigation had been commenced against my client here, that they would not allow any shipments to go through. So shipments were literally blocked for 9 months until the court battle ended. What I had to do, they weren't monitoring IP filings in Canada. I actually looked at the IP. The examiners missed some key prior art that was registered in Canada, including the company's own IP. I was able to ask for re-examination, got it reviewed, and ultimately the patent was invalidated. I then had the Chinese lawyers who I was overseeing use those arguments and that decision, and along with some other decisions, who then eventually had the IP transferred, invalidated, the patent invalidated in China as well. I had to threaten who at that time was the wealthiest man in Asia, who had now taken over the trademarks fraudulently, made him transfer them back to my client. All of this took 9 months to get everything back on track, the shipments going out again. And then this caused a lot of damage to the company, because they weren't seen as a reliable supplier of products, and had a huge, huge impact. The key to all this is you need to really have a fulsome strategy about everything you're doing to protect and manage and make sure that your business strategy is going to be successful. Let's compare this with a very good example. Everybody knows Amazon, but really in depth, a lot of people don't know in depth. I mean, there's a photo of Jeff Bezos there. That does not look like a very really good start from where he is there. You can see what he started with. I know he had to get money from his parents from their retirement in order to keep things going. But people don't realize how smart his business strategy was and how it aligned with his IP strategy. He knew at that time the potential of the internet, to be an online store. So what did he do? He focused his strategy. He said that because physical bookstores were unable to offer the vast selection of available books, an online format would be ideal for luring millions of book lovers. So his strategy was to drive business by prioritizing innovation and operational efficiency as core elements of his business strategy. So he was always thinking of customer-centric solutions. What was his IP strategy? He filed for IP that focused on operational efficiency, which aligned with the business strategy. His first patent was for its one-click ordering method, which was it would record payment and shipping info saved to an account so that a customer purchase could be made with one click. And this provided a competitive edge in the online retail business. Apple even later licensed this technology for the iTunes platform and that. Then, so because he was so focused, he got commercial success. He was then able to enlarge the business. And now what they're known as the store of everything. I can't remember what it's called. But they've been able to break out, make this evolve into something so much bigger, but it's always focused on customer-centric solutions. So that's why they now have thousands of patents on cloud computing, web management, networking tech, all sorts of things. But a lot of people don't realize how he started out and why his strategy was so important for success. So if you're wanting to know then, okay, how do I do an IP strategy then? I think we've already talked about the key elements and what's necessary. But I think you'll realize from what I've said then, you've got to have a great understanding of what your IP is, which isn't always obvious. And you have to therefore do sort of a systematic and comprehensive review of your internal IP assets. And in this respect, one thing always comes to mind is engineers. Whenever I talk to small companies and that engineers, I talk to them. Well, what have you done? What do you do things that are inventive, novel? And I swear 90% of the time they say to me, well, I'm an engineer. My job is to come up with solutions to problems. I said, exactly. So you might be coming up with innovations. And so they don't think of it that way, though, a lot of engineers. So you really have to get out what your true IP assets are. And then along with an IP audit, we've talked about a landscape report. This is an external IP audit. You need to know what your competitors are doing. An IP policy, an internal IP policy, we're going to talk about that, is very important as well. Having an IP culture. So then when you take all this together and you've got your business strategy, which is being honed constantly as you come up with you do your landscape studies, your internal IP audit, all of them drive the business strategy because it's going to direct you to a specific market, a specific place where you can be commercially successful and from which you can launch you into different areas. Once you've got that, then you're going to have an IP action plan that should detail the steps outlining the specific goals, objectives, and actions and indicators of the IP strategy. And we can talk about this a little more in depth. And one thing I want to say now, I know we started late, so we don't have that much, I don't have as much time as originally thought. You can, after this, you can reach out to me, and I've got a lengthy document. I actually initially drafted it largely because I presented to a bunch of IP lawyers this past January about how to come up with a proper IP strategy. I'm happy to give that to the people in attendance as well so that it can help them with the development of their IP strategy. But as I've been going over, an internal IP audit is important to identify existing and potential IP assets. You know what you've got. Once you know what you've got, it'll lead you into thinking about where you can go from there, possible areas. A key thing is also an IP audit will allow you to know if you actually own the IP assets that are strategic to your business. Was the IP developed with the help of a university professor, maybe some university students? You better make sure the documents you've signed, the different policy there, that your company actually owns them. A lot of times the university might own it. And at the same time, students have different rights compared to professors and that at a lot of universities. So just be aware of this. A key thing about an audit is to make sure you actually own. Once you do an audit, you'll be able to identify coverage and gaps with your IP. If you filed and you've got registration of a patent, well, that doesn't mean it doesn't give you a license to do everything you want necessarily, and maybe even the protection that it affords you is not as good as what you thought. You may have narrow scope of claims that only help you so much, where potentially competitors could easily get around it. It's important to understand these sorts of things, and that's where in this SWOT analysis comes in. You're going to identify and assess the strengths, weaknesses, opportunities, and threats to your IP assets. That's a key part of this. Optimize the use and value of your IP assets. Reduce the costs associated with IP ownership. Uncover unused assets that cost your business money. I gave you the example of the company in the cloud data center. I mean, they had filings in Russia and all over the place, which were not necessary and were costing a lot of money at the time. So you've got to be able to identify, assets that are costing you money that aren't even necessary as well. Identify underutilized assets that can help you generate revenue. Maybe you have IP that isn't central to your strategy, but maybe there's a use to it in different sectors, and you can license it out. There's all sorts of things that from an IP audit, that it helps you with these understandings. It facilitates IP transactions and collaborations. Once you know what you have and your strengths and weaknesses, you can figure out which sort of other institutions, companies you should be collaborating with to help advance your business and your technology. This is a big weakness I find in Canadian companies, especially at the sort of startup SME phase, is they're not very good at identifying collaborative partners, to work with. And you don't have to do everything yourself. If to get to the next stage is going to take you 6 to 12 months, maybe somebody else already has something and you can work together to get there a lot quicker. Identify IP assets that you're using that may create a risk for your business. Example, open source software. I know an example of someone, big company, whose engineers created software where it turns out once the lawyer investigated it, he talked to a couple of the engineers and they said, "Oh, sir, don't worry, we're not infringing any IP of anybody else's software. We copied their code and we changed all the ownership in there to our company and just simply changed the names of some variables in there." In other words, they copied it and just changed names to make it seem like they didn't, and they admitted this. And they thought that they escaped infringement by doing this. The lawyer shut things down, and it took another 6 to 8 months to get the software back on track and before it could be marketed. And like I said, it helps you align your IP strategy with your business goals. I'll just quickly go through this. It's up on the screen. We're running out of time. But you need to go through all sorts of things. IP isn't just the patents you own, the trademarks and things like that. Your IP strategy involves how you've dealt with your employees, contractors, other stakeholders, suppliers, and that. So even things like agreements are key. And they need to be analyzed so that you can fully understand that you're protected to preserve your business strategy. So, for instance, I always bring up different clauses. You need somebody, a lawyer or someone who can look at these things to help you out. And here's an example, what I put in, like master development agreements. And one of the terms tells them that developer shall not file any application in any jurisdiction seeking registration or IP relating to any innovative IP conceived, created, invented, or otherwise developed respecting any services or deliverable. And then after that they shall not oppose any valid and enforceable IP held by the company. This sort of clause would have been extremely useful if my client I told you about in the retail sector had that in their agreements with the Chinese, manufacturer. Same with, contractor IP agreements. Do you have clauses which, and I'm just going to pick up something here, where if they, after the fact, so that even if they assign their IP to the company, sometimes you'll get disgruntled employees who leave and then they won't help you with any filings. Well, in the US, the inventor is the first owner of patents, and they have to sign different documents. Well, I've had a situation where they wouldn't do that, but because I had terms like this in contracts, it protected the company. And in here, it says if the participant was unavailable, unwilling, or incapacitated to sign or any sort of documents, essentially that the participant, the person, hereby irrevocably designates and appoints a company and its duly authorized agents and officers as this person's agent to sign things on his behalf. In other words, the company is then able to do whatever they want, because even if this person's not willing to assist, the company can take the steps necessary and sign on the person's behalf. These are just little things where I'm trying to get you to think an IP strategy involves more than just registered patents and that. It's the whole gamut of how IP in general and how you protect your IP, how you enforce it, all that comes together with your business strategy and to make it successful. An external IP audit is we've gone through extremely necessary to understand the IP assets and rights of competitors and other relevant actors in the industry, such as suppliers, customers, and collaborators. Now, unfortunately, I've seen that there are many different funding organizations that have now stopped so much allowing different IP landscape studies to be done for them, and they're not funding them as much. That is a real shame, because as I've talked about, as Roger Martin talks about, you need to know what is going on in your market with your competitors and that to be able to have a proper IP business strategy and proper IP strategy. And I'll tell you, it's not always just your competitors. You need to know what your suppliers, customers, and collaborators are doing as well in some cases. There's sometimes you're collaborating with someone or have a supplier. They may actually become a competitor because they may be developing IP which they actually want to try and market themselves instead of being in business with you. And so then they end up going it alone and you lose them as a supplier or a collaborator or whatever. So you always have to be aware of this. You've got to have backups. Your strategy has to be flexible depending on what is going on. And IP landscape studies help you understand the activities of competitors and what they're doing in terms of innovation and research and development as well. You can kind of see where the market's going. Now, the problem with patent applications is they're not published for 18 months after filing. So you're always a little bit behind the times in terms of the information you glean from patents, but obviously it's still relevant and you can do other market studies as well. But it's important to understand where the market is going. Like it says here, you identify IP trends and patterns in the industry. But you also, with landscape studies, you identify IP opportunities or white spaces. This is critical for trying to figure out where you can innovate. Because remember, an innovation strategy is part of a business strategy as well. Where can you innovate? Where can you get IP rights? Will this give you a business advantage, a competitive advantage in the situations? You want to be always looking for opportunities. You can only do this if you're looking at the market with a sort of an IP landscape to understand what is going on out there. They also help you develop contingency plans and design around based on competitor IP rights. You don't want to be out there with your head in the sand. You're better off knowing what your competitors are doing, because if ultimately you're bringing something to market and you're just going to get sued right away for infringement, that helps nobody. You want to have plans about how you can design around different patents, and sometimes that even leads to innovations. you can see, design arounds sometimes lead to better things. So you're better off knowing what your competitors and others out there in the market are doing. It helps you avoid IP disputes and conflicts, and once again, allows you to adjust your IP strategy. The IP policy, and I apologize that we're a little bit beyond what we were going to be talking here, but because I started late, I'm trying to just get through this very quickly. And I will open myself up for questions, and I will stay as long as people want. And like I said, I will provide a document that can be very useful as well. But to get to this, an IP policy, you need to make sure that you have a policy which is well understood by the people in your business. You want to have a clear and comprehensive IP policy that defines the roles and responsibilities of the employees and stakeholders in relation to IP creation, ownership, protection, all these aspects. And it's important that the policy lays out the procedures and processes for IP identification, registration, disclosure, etc. Here's a big problem. You got to make sure your employees aren't out there accidentally disclosing your technology. Some jurisdictions in particular have requirements of absolute novelty, meaning if you go out there and you disclose your technology, you're not going to be a patent for it out there. So you have to be very careful. You need to set all these things out in an IP policy. A lot of businesses have clean desk policies. When you leave for the day, make sure that there's nothing that anybody can take, all sorts of things like that. Fostering an IP culture is part of an IP strategy as well, because it encourages, enables employees and stakeholders to recognize, respect, and leverage IP as a strategic asset. And it encourages IP creation, protection, management, and exploitation. You got to make sure that the leaders are involved, that they're committed and supportive of and communicating the importance of IP to all the employees and everyone else, because it's important to make sure that it trickles down to everyone, because and if you look at companies like Apple, they make sure that they do this. Everybody's fully aware of everything. Governance, well-defined effective governance structure that assigns and distributes the roles, responsibilities, and accountabilities of IP activities and ensures coordination and collaboration among different levels of the business. Education, this is absolutely key. Continuous and comprehensive education program that raises the awareness and knowledge of IP among employees and stakeholders, so that they understand the importance of IP creation, protection, management. That's why programs like ElevateIP, having organizations like North Forge, are so important to helping you with your business strategies. They help with education, all sorts of things like that, putting on these different webinars. Make sure you keep this up, this sort of thing. This is how you're going to gain a competitive advantage. Incentives. Make sure your business is having incentives, rewarding your employees for contributions that they make, motivates them and encourages them to engage in IP activities. There's so much more that can be part of a culture as well, but this all fits in within an IP strategy that aligns with your business strategy. Once you have all this together, the IP policy and everything, you'll have learned what the key IP assets are to your business, where your innovations are, where they're going, what your competitors are doing, and everything. So you need to outline, have an action plan for the next steps that you're going to take with your IP, whether that be filing for new patents to key technology that's going to provide you with a competitive advantage, or whether you're going to use your trade secrets in certain ways. And you're going to make sure that you record all of your trade secrets with details about what they are, who came up with the trade secrets, and when. Apparently, TMSC, Taiwan Semiconductor Company, one of the best companies in the world, they apparently have tens of thousands of trade secrets because they're better off keeping them that way than filing patents on them. And they just have to make sure that there's no disclosure. And they've had some recent cases of people trying to steal it for different Chinese companies, but that's the strategy that they have taken. But when you come up with an IP action plan, it outlines what you want to accomplish with your IP to further your business strategy. So it should detail the capabilities, management systems, processes, and everything that you need. And I always say for your IP action plan, you need to use SMART criteria. And that is, SMART, be specific. The IP action plan must have goals and objectives that are clear, concise, and unambiguous, and state exactly what is to be accomplished. This is very different from the company I told you about, where they just filed for everything, not knowing if or how it would help with their business strategy. Make sure they're measurable changes, measurable things that you're putting into place. It should be quantifiable, verifiable, and trackable, and have indicators and metrics where you can really figure out how this is helping you, over time. Make sure that any IP that you're seeking registration for, that in your IP action plan and that, any steps that you're taking, that they're achievable. Are you trying to get realistic, attainable things done, given the resources and constraints on the company? Again, sometimes you want to consider whether just to keep things as trade secrets, or what should it be that you're patenting? And, maybe you have 7 to 10 different innovations there, but maybe only 4 to 5 are key. Maybe focus on filing for those, and the others can be trade secrets. These are all things that go into determining what your IP strategy should be. Make sure this is related, that it's relevant, that it's going to give you meaningful, important, and beneficial support to the overall vision, mission, and goals of the organization, the business strategy, and make sure it's time bound. You got to move as fast as you can these days, and so make sure that you're not doing things in isolation. You want to have an IP action plan that is going to put things in place that are helping your business achieve things as quickly as possible. So you need to have a definite start and end date and a clear timeline and deadline to get things done. And so just make sure that you're doing this. And like I said, I've got a document that will help with how you actually go about implementing all of these things, including an IP action plan. So please reach out, and I'm happy to provide you with that. And I will leave it there for now. I know we've gone over, but I'm open for any sort of questions.
Awesome. Thank you so much, Geoffrey. So it does look like we have some questions in the Q&A. I'll get you to stop sharing your screen if possible, because then we'll pop up on the big screen, the two of us. There we are. Okay, so a couple questions. It looks like Perry is wondering about a basic cost of patents. Is there kind of a rule of thumb when it comes to patent costs?
So it's not an easy question necessarily, but often, it depends on what your IP strategy is. Do you want to file a US provisional patent application and then later within a year file a regular application, which can be an international PCT application or what's called a national phase application, let's say in the US and Canada? This is a difficult topic to get into, right? So if you're not that familiar with patents, what I'm saying here may just go over your head. And I'm trying to be, as basic about it as I can. But if you want to do an initial filing, and just a rule of thumb, you're going to look to anywhere from $10,000 to $15,000 for a first drafting and filing. You want it to provide an enabling disclosure. No matter what, people think of a U.S. provisional. Oh, I can just file a quick and dirty provisional. They're of no use. You have to provide an enabling disclosure, which would allow a person skilled in the art to make and work the invention as readily as the inventors themselves, simply by reading the patent disclosure and putting it into practice without undue effort and research. So, that's why you can't get them done for too cheap, and you're going to be looking at least in the $10,000 to $15,000 range to start.
Yeah, exactly, to start, right?
Yeah, and because then that's when all the different costs follow. You have to file a regular application after a U.S. provisional a year later. When you actually enter into the different countries, let's say Canada, the US, because you don't have a worldwide patent, right? You have to get patents in all the different jurisdictions. And so each of them comes with a cost. So, you have to take advantage of the timelines involved to allow you to save up money, to be able to meet those costs down the road. And then when you have great programs like ElevateIP, it can help with some of these costs.
Absolutely. Perry just made a note in here, and Perry, I would caution you. So he just said, I spoke to a patent attorney who said it would be only $800. Just caution, caution.
Ooh, I would not want to see how that was created, that patent draft. And the only thing I can suggest there is somebody's going to try and take some information you provide, throw it into an AI program that's going to spit out something for you. And you know, you need to work with IP professionals. You know, everybody understands the costs involved, but these are a lot of work to do properly. You need proper figures. You need a proper disclosure. So don't ever go the cheap route. It's not going to get you anywhere.
And a patent agent, that's a very specific role, right? There's education and there's testing that are involved in becoming a patent agent, which also includes as to why it's so expensive, because there's only a handful. Correct?
Exactly. There's so many, you know, experts out there, and there's a lot of great IP professionals, you know, across this country who can help you with your specific technology. I would encourage you to speak to several different people, see who you feel comfortable with, and try and work with them, and especially under these different funding programs, they can try and do it in a reasonable manner, you know, for you.
So we have here around different classifications around IP. So one is especially when using an LMS. Or LLMs.
Yeah,
LLMs.
And so what about them in particular? I mean, did you want...
What classifies as IP when kind of talking about LLMs?
Well, it depends on what you're using them for, right? LLMs are, you know, teaches, you know, it's what's used to generate different, you know, chat GPT and that, you know, large language models, all sorts of different things that they use. So, I mean, IP is intellectual property that's developed by people, you know, in general. Now, can you use an LLM to have some sort of innovation still? That's the possibility. There's some arguments out there with case law coming from other jurisdictions that as long as you are the person directing, you know, the LLM with certain information, you're directing everything that they do, that every step that's taken is because of the prompts that you're giving and what's coming out, that there may be, you know, authorship or inventorship in that to the person. But, you know, really the best thing to do is to not use them in terms of innovation, thinking that that's going to provide you with innovation, to be honest.
So kind of sticking with that, and we have AI and everything's coming around. So there's a lot of open source software, right? It's very popular. Someone asked, open source software is popular right now. Can I still protect my IP and have open source? If not, what's the advantage to opening up source code?
So open source, definitely you can use. It's, you know, what you're getting, let's say, a patent for. So first of all, some people think that you can't patent software. That's not true. You have to describe it and disclose it and claim it in a certain way to be able to claim the functionality that you get, you know, when used with a specific, you know, with computers and that, in order to get a patent on it. But you can certainly use open source. The key with open source software, I kind of mentioned this in my talk on one of the slides just very quickly, is that you need to make sure you're using permissive software where you are allowed to do anything with it, you know, commercial use, private use, whatever, first of all. And a lot of people don't follow the licensing requirements under open source. Some of them require that you acknowledge the author in sort of an open source notices file and have a copy of the license along with it. So you should always have your open source code plus an OSS notices file that meets all the different licensing requirements and tells individuals what different open source components you've used for your software. But obviously, you're going to have some innovative aspects of your software too that you don't have to disclose, right? And the way you put together the open source code from different components, along with your own coding, you can certainly get, you know, a patent to that if you've created new functionality that's come out of this. Novel, non-obvious innovations. So you certainly can. And the benefits of putting it out in open source sometimes is the fact that you become known, the company becomes known as a reliable source of open source. And sometimes you can develop environments in software for certain functionality where people are using your code, but you have a jump start on them because you've then provided all these other modules as well that builds on it. And you can eventually get it where some of the things you build are open source and other ones, for free. Other ones, they have to license to get increased functionality. So sometimes there's a benefit of putting your open source out there, especially if you're creating a new environment, like I said, and where you can use it for your own benefits down the road and become a big player for the environment that you're creating.
So you had talked about landscape studies in your presentation. Would you be able to expand a little bit on them?
Yeah, so landscape studies, I mean, it's broad, but you have searches. And here's the thing. There's different companies that can help you with things, with these landscape studies, and they specialize in doing these things. So they look at your technology, or I would, if I'm doing a landscape sort of study, of IP professional, you look at your technology, and you want to see, you look at the different concepts that what your innovation relates to, what your main, key IP is. And you want to do patent searches and different market searches to see what is going on in that field. What are other companies doing? So, if you were in the autonomous vehicle, area, and you think you've come up with a new system for improving battery charging, where you've created a much quicker battery charging system. You want to go out there and you want to see what other companies in that field are doing, the Teslas, the BYDs, BIDs, and all these other companies. What are they patenting? What is their technology related to? Is what you are doing different from what they are doing? Because if not, then you want to find a way to get around what it is they're doing. Or maybe you change, your tactics and you go for something slightly different. You hone in on an area maybe where you learn that there's some white space. So it's a matter of doing different searches, and for instance, patent searches, which using different keywords. There's a lot of different AI search platforms out there now where you can put in paragraphs describing your technology, and it will help you go out there and locate these different relevant prior art patents and that. And that is what you base your studies on. You determine what others are doing, where technology is going, any white spaces and that. But that is just in essence what you do in a landscape study.
Okay. One other question we have is, given that my business expansion plans is having future features to be developed, how best can one protect the future IP based on that race for the lead time to file the protection?
Yeah, so I mean, you want to be, in patents, first to file is very important, so for future features and that, of course. You want to be monitoring the market to see, if these features are already out there, and if not. Part of the problem is you want to make sure that you know how to do it, because a patent application is what the government is essentially doing is they are giving you a 20-year monopoly in exchange for a full disclosure of your invention. And what that means is you're providing an enabling disclosure. You're telling them how to make and work your invention such that when the 20-year monopoly period is over, anybody else can go out there and do it. So you want to make sure that you're disclosing it in such a way where you know that it has utility, that hopefully it's going to work, but you want to disclose also different embodiments that you can envision, and make sure that those are covered as well. At the same time, you can file, let's say you filed it as a US provisional application. Each time you come up with new advancements, maybe you've changed course, you've learned new things, you've got new aspects to it to create, maybe you learned problems that you were coming up with when developing this, and you figured you have to do this and that to actually get it to work. Disclose that in a further US provisional. Because when you do a regular filing down the road, as long as it's within a year, you can claim priority back to these different filings where you're disclosing your invention. But the key is, for new things you're coming up with, keep it under wraps. Make sure you're not disclosing it to anybody at all out there, and otherwise file as soon as you can, unless it's the sort of thing you determine is good to keep as a trade secret.
And the last one, and you talked about it a bit around like the open source component. So someone is AI is used in professional music and film production now. How does AI affect software development now when it comes to IP?
Well, I mean, I heard, software development here, I heard, I think the CEO of Google, was it Google or Microsoft, saying that basically right now, 30 to 40% of all code, that comes out of Microsoft or Google, I can't remember which one it is AI derived.
Wild.
It's going to be more and more. And so, you're seeing all sorts of things on even different music platforms, Spotify now, where they've got different artists coming out, which are wholly AI generated, the music, the way they look, everything there. And they're having to disclose that. The problem there is you're not going to have protection over things like that, unless in some jurisdictions, some of the case law, we're going to have to watch how it goes, unless, like I said earlier, you are directing it very specifically, and you're practically being an author yourself of the music. Because your direction is so specific in the creation of it, maybe you have authorship in those sorts of situations, but it's not a given, and you've got to be very careful with AI.
Yeah, absolutely. Looks like we got one more. Perry is wondering, for your expertise, trade secrets or patents? What's best, do you think?
It all depends on the situation, and I'll tell you this. So there are certain patents where the problem is, and you got to think of this. Imagine a software patent directed to a certain algorithm. Now, some algorithms are easy to figure out what's going on, in them, because you can see how the apparatus is, let's say, responding to the code. It's a certain functionality. It's doing these steps, and it must be doing it a certain way. There's a lot of software out there where it would be very difficult. You've got it patented, and you've got claims to, specific steps that it's taking, but where it would be very, very difficult to detect if a competitor is actually using, your innovation that you have patented. Very difficult. So then the problem is, if you're having difficulty, determining, discoverability of this patent, this sort of algorithm, then you're probably better off in some situations keeping it as a trade secret. The problem with trade secrets is you had better have all the security provisions in place, everything locked down, well recorded. You've got to know what your employees and contractors are doing. And you had better have things in your contracts making sure that they know that they can't take any IP with them should they leave the company, and taking steps even. Sometimes if they're going to a known competitor, you want to have your lawyer reach out to that other company and just give them a warning saying, by the way, we understand they're going there. He was aware of a lot of trade secrets and stuff, which you better make sure is not being disclosed to your company. So it really is, this is the thing, and this is why you have to do an IP strategy that involves an IP audit. You need to know what's going on out there in the industry to be part of your business strategy, because you need to learn these things. You need to figure out, do an analysis of each IP. Should we have this, keep this as a trade secret, or should we file a patent to it? What's going to help us?
There's one more. So Perry asks, are NDAs acceptable to demand? What are your thoughts on NDAs?
Are they acceptable to
ask for, to demand, he says.
Oh, always have, non-disclosure agreements, and you've got to make sure that they're protecting, all of the confidential information that you're going to disclose to them. and that it covers even any derivative works of that confidential information. Let's say the information that they take, if they put it in their own form, internal forms to study, if they're trying to figure out if they want to have a business relationship with you, then make sure it covers that as well. Anything that relates to the confidential information you're disclosing is covered by it, and that it needs to be destroyed or returned to you should you not have any sort of arrangement with them after the fact. And I'm going to tell you this though, you've got to be very, very careful with disclosure, what sort of information you're giving to outside companies or whatever. I'll give you this example. And this, I've seen this happen a couple times. A guy I know had a really good tech company who was approached by a absolutely massive Chinese company that everybody is aware of. And they were approached saying, we love your technology. We're thinking about, we'd like to either license it, or best, we think that we would like to buy your company. So they get into NDA, they have an NDA, and then they have a certain level of disclosure to try and determine if they're going to enter into a business relationship. This has happened many times with this large company to Canadian companies and others. They get right to the end, they learn as much information as they can, and then right at the end, the person they're dealing with says, I was just talking to the CEO today, and sorry, this isn't the right time, we're going to back out. They've learned as much information as they can from you, and you're going to have a hell of a time trying to prove that they took your IP or anything like that. So always be aware, disclose only what is necessary, and never ever give away your secret sauce. Make sure that you're disclosing things at a high level, because you never know which way things are going to go.
And last one, Brady asked in the chat, on average, how long do design patents take versus utility patents?
I love design patents, industrial designs as they're known in Canada. I'm telling you, they can be very powerful too. If they cover a specific look of your product, it has been that industrial designs at times over utility patents, and this depends on what the technology is you're dealing with. But it is so loved by customers, and that the way yours looks, that it provides such a competitive advantage. And when you file industrial designs, I find that sometimes they are just as powerful at stopping competitors from entering the market. And I've used them really successfully. And when you file them, you can usually expect an examiner to examine them at CIPO. I believe it's around 8 months. And if you've got your figures, they're easy to file too, if you know how to do the drawings for them. And by the way, CIPO has a great manual, practice office manual on industrial designs, which teaches you how to do these drawings, what you should show in them from the different angles. It's fantastic. If you do decent drawings from the outset, you may get an examiner examining it within 8 months and that. And if it is something novel, unique, there's not anything else that's registered that looks, the same. It's substantially different, effectively. Then I find that you may have to overcome a few little objections, but often you can fix those, and so you'll get registration then another, maybe 4 months or so from there, if you get things through around there. So you might be looking at a year or a little longer for different registrations.
Awesome. Looking at the time, we're running 3:32 our time. There's a couple more questions in the Q&A if you've got a couple minutes still.
Happy to. I was able to move my 4:30 meeting. Yeah.
So Mike in the Q&A is asking a little bit more about NDAs. So would you recommend an NDA prior to innovation? For example, doing early phase market validation research, I often see companies asking for NDAs and they have a hard time getting connections. But I guess it would kind of depend on what you're trying to disclose or what you're asking for, correct?
Exactly. I mean, what is the level of the market analysis? Are you disclosing information to the level where you're giving away, some real key technology, information about key technology, any sort of trade secrets, anything like that? So the key about NDAs is you just have to manage them, right? And make sure you're aware. A lot NDAs can be different. Sometimes they're for a specific time. And for a few years. It protects your confidential information for maybe 3 to 5 years, and then after that, sometimes there's a period also tagged on, a couple more years under which maybe you just have a disclosure period for a couple of years, and then after that, it's got to be protected for a few more years. It really depends on the situation, because there are organizations out there who do not like signing them. And in fact, I will tell you as an example, a lot of investors, especially investors from California, and that if they sign NDAs half the time, they do not want any beyond a year. And I know examples. I've got a guy who's started 4 or 5 different businesses, and he was meeting with investors in California practically every other week for years. And he says, these 1-year NDAs are practically useless too, half the time for them, because they just freely go around talking to each other, these different investors, saying, hey, I saw this out there, you might want to think of this, in talking to them. So be very careful. It all comes down to managing timelines in the NDA, how long this company has to protect it for, because that will, let you know, okay, I really don't want to be providing much information if it doesn't provide me with much protection for only like a year or whatever. So the terms matter. Just because you have an NDA doesn't protect you. Look at the terms and see what kind of protection this NDA gives you, because there's key terms that you should have in an NDA.
We're gonna flip it over to more on the creative side. So guys wondering, how do art installations relate to IP? Around art installations, yeah.
So art installations and like, where would that be? So a great example of an art installation situation was years ago at the Eaton Center, I believe, in Toronto. And I can't remember, I should know this right offhand, but it was an art installation, I believe, of geese or whatever up on the ceiling area. And there was a problem over them wanting to change the way, I guess, it was displayed. And the author, though, he had copyright in as an artist of the way that art was put together, the way it was specifically designed. And he didn't want changes to it because it affected the artistic value to him of it. So you, as an artist, you can have not only copyright ownership, but moral rights in your works of art, which means you have the right to be associated with the artwork, and the right to make sure that it's produced or seen in a way that is acceptable to you. So you can have different ownership in different artwork installations depending on how it was done. Now, if you're simply installing art, at one art piece that was developed by another, a painter, for instance, or something, well, the painter would have ownership of that particular artwork.
Right. Guy says it's an outdoor installation on private property, which I think would still, depending if they're the artist, still reflect.
Yeah, and the thing is, so if it's for a private person, I mean, is there a contract that's in place? Are they, do you have the contract where they are? Because the problem is, if they're paying you for this, then, they might be the owner then of this copyright. But you may still have moral rights in the artwork where you have to be associated with it. Like I said, and it has to be displayed in a certain way. And if they try and change the way it's displayed, then that's a no-no, and you can go after them. The thing about moral rights is, so you can assign copyright ownership. You can assign it to another company where they then become the owner. Moral rights you can't assign. You can not enforce them. So you can say that you will you give up your moral rights in the work to be associated with it or whatever. So that's a different thing. The key is, you want to come to an understanding. you want to have an agreement ahead of time with this this person or wherever it is, this private company, whatever it is.
Well, it looks like that's the end of our questions that are up there. But Geoff, thank you so much. I really want to thank you for taking the time and for staying longer than our intended, and for working with us on troubleshooting.
Yeah.
We really appreciate you taking the time in your day to share your expertise. Lots of claps coming up on the side, so I know, and to still have a number of individuals in the room, very valuable, and we really, really appreciate it.
Yeah, no, thank you very much. Happy to do this. I hope a lot of people were able to stay on because of whatever I did, not being able to get on properly. Anyway, but once again, I'm happy to give some different documentation that may be of assistance for people who want to implement a proper IP strategy.
That's wonderful. And Kara, our program manager for ElevateIP, will be sending that out. Once she receives it, she'll send it out to everyone that was attending. Thank you again. So now we're going to head back to the networking floor. For those that still want to do some networking, feel free to stick around for another. It looks like we have 5 minutes left on the clock I've got in the top corner here. And for everyone else, thank you so much for joining us, and enjoy your day.
Okay. Thank you so much.